Yeah, I'm really happy to have this presentation, which I get a lot of questions as General Counsel of American Pharmacies about pharmacy ownership changes, and it can happen in a lot of different ways. And there's a lot to consider when you're going through these things, whether you're a purchaser or seller, or you're trying to bring in someone on your team into ownership. It can come in a lot of different ways, and there's always, as much as I think people think they know, there's usually a little bit more to the story. And I'm really happy that we have with us Jeff Baird and Bonnie Bond, and Scotty Sykes was going to be on it, but he came down with the flu last minute. But which I think to all of our benefit, although this is recorded, I probably shouldn't say that, but because Bonnie's a fantastic and experienced
it's
CPA.
the B team. The B team is here. So.
No. Bonnie's the best of the best. You guys got the A team right here.
So for those that don't know Jeff is an attorney practicing really with clients all over the place. But he knows there are a lot of good lawyers out there, and there's a lot of lawyers that know a lot, but there's very few that know as much about the intricacies of pharmacy law as Jeff does. And that's really important because, as we all know, pharmacy is not in many ways a typical business. There's a lot of idiosyncrasies to it. And Jeff is certainly familiar with that. And for the same reason, Bonnie and the whole team at Sykes & Company have developed a great specialty. She's a CPA, and she's the transitions director at Sykes & Company. But her and the entire team at Sykes & Company have developed very good specialty in knowing about what's important to pharmacies and where the pitfalls are and what to watch out for. And so these are two people that can give anybody a lot of advice into these various questions about pharmacy ownership and transitions. So with that, I'll just go ahead and kick it off to you, Jeff and Bonnie. And
thank you.
Thank you.
Thanks, Miguel. Hey, folks, it's an honor for me to be able to speak with my good friend, Bonnie Bond. She's a CPA. She's part of Sykes & Company, which is a national CPA firm that specializes in representing pharmacies. And Bonnie's been a good friend for a long time, and she and I work together in representing pharmacies. As Miguel mentioned, I'm with Brown Fortunato. We're a 30-person law firm that we do nothing but healthcare, and we represent pharmacies and other providers in all 50 states. I've known Miguel for a number of years, and American Pharmacies is very fortunate to have him as general counsel. Now, Bonnie and I have a whole list of things that we're going to cover with you, and we're going to tag team. We're going to interrupt each other. We're going to interact. It's going to be a lot of fun. And so let's get going. First of all, trends. The demand for pharmacy services is only going to increase. We've got 78 million baby boomers retiring at the rate of 10,000 per day. Right after them, we got the Gen Zs, and then we've got the millennials. And so the demand's only going to increase. And the demand for certainly for chain pharmacies, I get that, but also the demand for independent pharmacies that can serve their community needs is only going to increase. We're going to see demand for long-term care pharmacies. We're going to see demand for specialty. In other words, the trend is that what we're doing is, as pharmacies, is very, very important. We're always obviously going to have to kind of fight the battle in terms of reimbursement, but that's just something that we've been having to do over the last several decades and will continue to do. But in terms of trends, what I'm seeing is new people coming into the market. I'm seeing independents buying out other independents. I'm seeing older pharmacists that are ready to exit the market. They're either transferring to family or they're selling out. And Bonnie and I are going to talk about all that. So Bonnie, what do you see as trends?
Same. Definitely seeing with a lot of the big box stores, a lot of those closures. We're seeing some backfill situations as well, or just where people are pulling in. Growth is heavy in some of those areas because some of the independents are picking up those scripts as well as those big box closes. But again, I mean, we get a couple calls a week for sure with someone wanting to purchase because it is kind of just fallen into their plate. Someone's ready to go and they're ready to go now. So that's what we're seeing. And then we've got a lot of the older owners who haven't, and they maybe have people in their store that have been working there that want to purchase that store. And those are some of these younger go-getter kind of types. And they've got all this stuff they want to do and incorporate and change. Diversifying revenue in those areas, and so they're ready to jump in and make changes. So we're seeing a lot of that.
And now let's go on ahead and set the table here. Stock purchase versus asset purchase. Apples and oranges, Venus and Mars. So, and I want to give you a distinction here. So we've got Miguel's Pharmacy Inc. It's a corporation owned by Miguel Rodriguez. And then I set up a brand new corporation called Jeff's Pharmacy Inc. In this scenario, Jeff's Pharmacy Inc. is going to buy the assets of Miguel's Pharmacy Inc. And all that means is that Miguel's corporation is going to sell my corporation all of its stuff. Its inventory, its patient files, its computers, paper clips, and bubble gum. My corporation, Jeff's Pharmacy Inc., I'm not going to be inheriting any liabilities from Miguel's Pharmacy Inc., but I'm going to have to go out and get my own pharmacy license, DEA permit, and PBM contracts. So that's an asset purchase. A stock purchase is a different animal. And a stock purchase, and then I'm oversimplifying this, but kind of bear with me. So you've got Jeff Baird individually and Miguel Rodriguez individually. Miguel is going to hand to me a piece of paper. That's it. And that piece of paper is going to be his stock certificate. He walks away, and now I'm the proud owner of Miguel's Pharmacy Inc. Now, let me dispel an urban legend. I am not personally taking on any liabilities of Miguel's Pharmacy Inc. It just so happens that this corporation that I just bought has got to continue to address any liabilities that it might have, known or unknown. As a general rule, and there are exceptions, but generally speaking, now that Miguel's walked away and I've taken over as the owner, the PBM contracts remain in place. The pharmacy license remains in place. DEA permit remains in place. The corporation just kind of keeps humming along like it always has. So those are the two types of acquisitions. It used to be back in the day that we handled mostly asset purchases. Now that has flipped, and we're mostly doing stock purchases because it's just easier from a regulatory standpoint. Bonnie, what are your thoughts?
I would agree.
Standpoint?
Agree. We're definitely seeing more stock purchases. There definitely can be a quicker close, especially in heat zones and things like that, where if you start from scratch, it could take years to get going. So, but we still see a lot of asset purchases as well. I would just add from an accounting perspective, because I know we get this question a lot at the ownership workshop that we do for NCPA. When you do, Jeff, a asset purchase, you are creating a new entity from scratch. And then that entity purchased those assets. So just so everyone's clear, when you do a stock purchase, like Jeff mentioned, it's just really a transfer of a piece of paper. So if I'm buying ABC Pharmacy, it's still going to be ABC Pharmacy after I take over. So there's no new entity that has to be set up. It's just a transfer of ownership. So just to be clear on that.
Now, Bonnie mentioned, we'll go ahead and jump ahead for a second. She mentioned heat zone. There are two types of heat zones. You've got the Department of Justice heat zones, and you have PBM heat zones. Now, Bonnie, if I go off the rails, bring me back on this one.
No problem.
But there's certain parts of the country that have reputation of just having too much fraud. And so the Department of Justice has designated certain areas, South Florida, perhaps, parts of Dallas, parts of Houston, parts of New York, parts of LA, others, that are designated as DOJ heat zones, um, meaning that really you can't start a new pharmacy from scratch. You really can't buy the assets of an existing pharmacy. If you're going to really in that type of heat zone, if you want a pharmacy there, you're going to have to engage in the stock purchase.
Right.
Likewise, separate and apart from the Department of Justice, there are PBMs by their own volition. They establish heat zones and basically saying, like, for example, Prime Therapeutics might say, in this part of Houston, if you open up a pharmacy from scratch or buy the assets, that's great. But we're not going to give you a contract for at least a year because we want to make sure that you know what you're doing and that you're not fraudulent. And so even then, in a PBM heat zone, you've got no choice but to engage in the stock purchase. So be aware of that. But if I've said anything incorrectly, Bonnie, correct me.
No, that's a great point. You just have to really remember, really do your homework, figure out where you are in this location and what makes sense. I'll add to, from an accounting perspective, stock versus asset, just so we're clear, when we're looking at tax benefits there, when you do an asset purchase, you are automatically able to get a step up in basis. So because you are purchasing things like fixed assets, and items like that, inventory, those things you're able to go ahead and get a tax deduction for, accelerate depreciation on, assign a value to it, for goodwill as well, all right up front, non-competes, equipment, and start to depreciate and take an expense and a deduction for that for tax purposes. When you do a stock purchase, basically everything is going to be goodwill, and that's going to be amortized over a 15-year period. And so it's a little different. So you don't get that immediate tax benefit. So just something to keep in mind, a difference in a tax perspective between the two.
Now, when you buy a pharmacy, in a sense, it's not rocket science. Okay. I mean, Bonnie and I and Miguel, and we're used to it because we wallow in this space. So we've got a comfort level, but that's just based on experience. If you've never bought a pharmacy or sold a pharmacy, you can go outside your comfort zone because it's a new experience. But in a sense, it's not terribly complicated. It's like buying a house. When my wife and I buy a house, we sign an earnest money contract, and then we hire an inspector to come out and check for the foundation, termites, and roof, things like that. And then if the inspector gives us a clean bill of health, then we go to closing at the title company and we get a deed. In a sense, it's kind of the same thing when it comes to buying a pharmacy. In terms of mechanics, let's say that, let's just hypothetically, Jeff Baird, went to buy the stock of Miguel's Pharmacy Inc. So first thing we're going to do is sign a mutual non-disclosure agreement. It's a 4-page agreement that really could be just 2 paragraphs, but lawyers prepare them and we charge by the word. So it's 4 pages with all kinds of whereas and heretofores. But all the mutual non-disclosure agreement says is that Miguel and I are going to exchange confidential information. We're going to keep it confidential. That's it. And then Miguel's going to give me his financials. In fact, Bonnie, so let's say that, so we got Miguel's going to give me his financials so I as the buyer can figure out what his pharmacy is worth. When you are representing the buyer of a pharmacy and you're looking at financials, what are you looking for?
Well, we look at financials, we look at tax returns, and we want to see the books and records as well. Because we've done this for a long time, and I can tell you that almost every time we've looked at those 3 pieces of information, they don't match. So we don't get the same information. So you can't just take a tax return by itself or just take a financial statement by itself. You really need to get down into the guts of what makes up those numbers. So that's what we're looking for. And we're big on, hey, don't put a number out there until you've done this, what we call due diligence work. Because Alan will always say, no one's going to forget that number. So if you put that out there to begin with, just even in conversation. No one forgets that. And then you do the dirty work and you find out that it's really worth this. It's hard to go back from that conversation. So,
Yeah, good point. Yeah,
yeah.
it's and so so you have it, and it's now what I'm about to say is self-serving. So bear with me. I'm a decent healthcare attorney, but I'm a walking, talking malpractice case when it comes to estate planning and family law. Um, Likewise, you know, a person's local business attorney is going to be just as smart as I am and is going to really know his stuff. But if he or she has not worked on pharmacy acquisitions, that attorney is going to get lost and make a mistake, because buying a pharmacy is a totally different animal than buying Joe's print shop. And so it's important that if you're going to buy or sell pharmacy, hire a healthcare attorney with pharmacy experience. And then same thing, Bonnie, about accounting.
Yeah, I 100% agree. We work obviously with a lot of your attorneys, and there's some other healthcare attorneys that we do business with, and it's just night and day when we work with these transitions. When you're dealing with an attorney that understands independent pharmacy, and when you're dealing with one that doesn't. And we can talk about some of those things that are very important to the deal in the documents that have to, be in those documents that are left out when it's not someone who truly understands it. It's definitely worth the money to do things right to begin with, right out of the gate, and get a good foundation and protect yourself. Having the right people in place and a good team.
And
So
I'll just
once-
chime
Sure,
in
go ahead,
and
Neil.
just to on that same point, because I do get a lot of questions about that from our members when they're calling about these kind of things. And this is just a strange economic model, this whole pharmacy business. It doesn't make sense in so many ways. And it's hard to convey that to even professionals always. And so the advice that you're going to get from people that are familiar with pharmacy and the business of pharmacy is just going to be really helpful to you. It's something that will save a lot of headache later on. So a lot of people are wondering, can I just do this transaction on my own? I'll just get the other party to the transaction to do all the documents, and I'm not going to get my own counsel or advice. That's a little dangerous to do, especially when you don't understand what the terms are in the deal. A lot of these terms might be daunting to go through. So getting good advice is always a good idea.
Yes.
Now,
Professional advice.
Now let's assume, so Bonnie and her team have gone through the financials and other documents, and we come up with a number. And we come up with what we think a good purchase price is. And so and often it's what's called a multiple of EBITDA, EBITDA, earnings before interest, taxes, depreciation, amortization. EBITDA is essentially net profit. And so, we've seen 3 to 4 to 5 times EBITDA. Sometimes it can be greater if the pharmacy is pretty unique. But let's just say that after your accountant and you as a purchaser, you come up with a number, then as a purchaser, you're going to prepare what's called a letter of intent. It's about a 4 or 5 page document. It's mostly non-binding. A few provisions are binding, but just lays out what the purchase price is going to be. It lays out how the purchase price is going to be paid. It lays out other terms and conditions. It just sets the parties' expectations. Basically, the letter of intent is the same thing as the earnest money contract when you buy a house. But it really sets the expectations of the parties. Bonnie, your thoughts about letters of intent?
Well, I was just going to ask your opinion on, because we had this conversation with a client yesterday, a potential client. They had already, so what's your feeling on letter of intents with amounts already assigned to them without having this due diligence information?
Well, you have two types you got different types of due diligence. And here we're, and a due diligence can be, pretty encompassing. The purchaser really needs to have a good feel for the numbers, for the finances, for the profitability before signing a letter of intent. Because once you lock in a number on the letter of intent, even though it's not binding, it's like an earnest money contract,
Mm-hmm.
it certainly sets the party's expectations, and it's hard to back off that. So you've got to be pretty sure of yourself as far as what you're willing to pay or what you're willing to accept by the time we sign a letter of intent.
What we see a lot is there are some sellers that are unwilling to provide the information. They don't want to share. And so it's very hard to explain to people when they really think they've got a good deal. I mean, and I don't know what they're basing it on, but they think they've got this great deal and they're going to walk away if I ask for this stuff and they're not going to give it to me. We see that a lot.
Well, and it's just one of the things I've learned as an attorney, and I'm sure Miguel's seen this, and Bonnie, you've seen this. I've never seen anybody go broke by walking away from a deal.
Yep.
I've seen people go broke by chasing after a deal because they get emotionally and psychologically tied up into the chase. You know, I've done it. I mean,
buying get excited,
buying a house or whatever it is. I'm human. I've gotten caught up in the chase where I'll make a bad decision. People do that, but it's really important that before you put that number there on the letter of intent, that you really know what it is that you're getting and you're comfortable with finances.
One thing I do want to, before we go too deep into due diligence, Jeff, is to make sure people understand too. Talk a little bit about the difference between, if you're doing an asset purchase, this due diligence process that we're talking about may not be quite as important, right? And the difference between what liability we're taking on between the two different.
No, good point. That's a good point. All due diligence means is that if I'm buying the assets of, if my corporation is buying the assets of Miguel's Pharmacy Inc.'s assets, or if I personally am buying the stock certificate from Miguel and I'm inheriting his corporation, either way, I've got to go in and, quote, kick the tires, close quote, of Miguel's Pharmacy, so I know what in the world it is that I'm getting.
Right.
Now, with an asset purchase, I still need to be thorough, but I'll use the legal term here. It's called loosey-goosey. So, I can, I might be able to not be quite as strict with my due diligence with an asset purchase, because as a general rule, I'm not inheriting I'm not taking on any liabilities. But I'll use another legal term. It's called paranoid. And by that, I mean that if I'm buying the stock of Miguel's Pharmacy Inc., while I personally am not inheriting any liabilities, meaning that my condominium in Aspen is safe, nevertheless, this corporation that I'm buying, it's going to continue to have whatever liabilities it has, known or unknown. And so I've got to be, I've got to know what's out there. I am okay. So all due diligence means is we gather information about the pharmacy we're buying so we know what we're getting. I am okay with a client of mine inheriting some skeletons. Skeletons are all right, as long as I know what they are going in. And so when we talk about due diligence, and I'm going to talk about it from a legal standpoint, and Bonnie will talk about from an accounting standpoint, things I'm going to look at will be, well, first of all, are there any recorded liens against Miguel's Pharmacy's assets? In other words, I don't want to give Miguel a whole bunch of money and find out some bank out there has got a security interest in the assets that I'm trying to buy. So I got to check that out. Is his corporate charter intact? What about his pharmacy license? Is that in good shape? What about his DEA permit? What about Miguel's Pharmacy's Medicaid provider number? I'm also want to take a look at the facility that he's in. Am I going to buy the building or am I going to lease it? If I'm going to lease it, then what are going to be the terms of the lease? I need to know all of that. I also am going to certainly, if this is a stock purchase, then it is likely that the PBM contracts will stay in place, but it's not a foregone, it's not a foregone conclusion. I need to look at those PBM contracts to see what type of notice Miguel's Pharmacy Inc. has to give ESI or Prime Therapeutics or Humana and prior to closing. In other words, the pharmacy's got to let the PBMs know with a stock purchase in advance that there's going to be a change of ownership. Miguel?
That's a big question I hear a lot is concern about the timing of that. Am I going to get approved? So if I become a new owner through stock purchase or asset purchase, I guess asset purchase is probably a more straightforward question, but even through a stock purchase, have you seen any problems where PBMs have slowed down the whole credentialing process or accepting them as a continued network pharmacy? Have you seen any issues pop up like that?
Seldom, not really. What we have found is that, and most contracts, Miguel and Bonnie, PBM contracts, and this is true even in the managed care arena, over with labs and hospitals and DME companies with Medicare Advantage, Medicaid managed care. But almost all PBM contracts will have a provision that says, if there's going to be a change of ownership, CHOW or CHOW, then you've got to just let us know. Let us know 30 days in advance, 60 days in advance. And there's no provision in there that the PBM has to approve the CHOW, but you just got to let the PBM know. Many contracts say that. Other contracts will say, well, not only do you have to give us, Optum, a 60-day notice of a change of ownership or CHOW, but we here at Optum, we have to approve the new shareholder, the new owner. Well, okay, you got to go through, so that particular contract, we have to get approval. Normally, it's not slow. Normally, it's not slow walked. Normally, there's not a problem. And so, but where you get into trouble with a stock purchase is when you just do it without notifying the PBMs, and then all of a sudden afterwards you've got to go in and seek forgiveness, and that's that's not fun. Now, just real quickly though, with an asset purchase though, those PBM contracts are not going to come over. If Jeff's Pharmacy Inc. buys the assets of Miguel's Pharmacy Inc., I'm not inheriting those contracts. Those contracts are not being transferred over to my corporation. I've got to go out and get my own contracts. Now, I'll be able to continue for a short period of time after closing. And in fact, we'll talk about power of attorney here in a second. But I'll be able to, Jeff's Pharmacy Inc., brand new corporation, who just bought the assets of Miguel's Pharmacy Inc. I'm going to be able to operate under Miguel's Pharmacy Inc.'s pharmacy license, DEA permit, and PBM contracts until I get my own. Well, that's basically true across the board. Yeah. Most states, you can do so with a power of attorney. Other states, it's a little bit more squirrely, but you can still do that.
So but this is where there's a good point to be made about using a healthcare specialist attorney with transactions. Right. As we see when people don't, this is one area in an asset purchase, people don't realize these contracts are going to be all this money, these receivable pay amounts are going to be hitting continuously after closing the seller's bank account. So so we have to make sure there is that is discussed in the closing documents about a reconciliation protocol that has to be followed. We like to see weekly reconciliations of those monies. That is your lifeblood. Your cash is going to 90% of it's going to be hitting the seller's bank account. We see 6 months to a year until you can get everything transferred over. So if those things aren't in the documents, I mean, we see people like, where's my money? Where's my cash? Oh, well, it's in the seller's bank account that they discontinued the day after closing. So you have to make sure that that is discussed, that it's left open, and that that reconciliation takes place using
And
the VOA.
this is an issue with asset purchases, but not stock purchases.
Exactly.
The stock purchase, Miguel walks away and is sitting on a beach in Cabo, and
Well, he goes to the bank first to change the signature cards.
Yeah, do that first. Yes.
On the way to the airport. Okay.
On the way to the airport.
On the airport.
Yes.
But the corporation just continues on like it always has.
Yep.
And so
same bank account. Yep.
Yeah, same bank account. So life is good. But with an asset purchase, until I get my own pharmacy license and my own PBM contracts, then the money is going to keep flowing into Miguel's Pharmacy Inc.'s bank account. And so it's just critical that we have something in writing that says, okay, Miguel, you can't take that money and go to Cabo. You got to leave that money's got to be transferred over to into my bank account.
And it's a little messy, just to really quick talk about this, because we get down in the weeds with this. Closing happens, those first 2 or 3 weeks, a majority of that money is still the seller's money, because it's when the script was filled, right? So then you kind of get into a 50-50 scenario as you move a few more weeks. And then usually beyond that, it becomes the buyers, but there's still outliers that still pop in. So you're pulling those 835 reports, you're looking at the dates that those were filled, and you're figuring out what deposits go where. So that's what, we call it a reconciliation process. It's very important, though, that that's done, or you'll run out of cash really quick.
Now, as an attorney, also things I look at are, for my clients buying a pharmacy, the pharmacy model, is it legally compliant, or does it violate the law? For example, we might have a pharmacy that my client's buying that's got wonderful EBITDA, that is wonderful net profit, and I'm going to be my client's going to be paying a multiple of 5 times EBITDA. But if I notice that the scripts that are coming in, the business being generated, is a result of a violation of state or federal kickback laws, or a violation of a physician self-referral law, or a violation of the False Claims Act, or a violation of the beneficiary inducement statute. In other words, the good news is the pharmacy that my client's buying is making a whole bunch of money. Bad news is it's ill-begotten gains, because the arrangements that it has with referral sources violate all kinds of federal and state laws. And so that's something that, as the attorney for the buyer, I'm asking questions designed to decide whether or not the business model is solid. Because the last thing you want to do is spend a bunch of money, buy a pharmacy, and all of a sudden have to just redo the business model because what it's been doing in the past has been fraudulent, and then it just all hell breaks loose.
It's not what it appears to be.
Right.
And just real quick, from an accounting perspective with the due diligence, like I mentioned earlier, we're looking at the financials, we're looking at tax returns, but mainly with the financials, a lot of accountants, just like with attorneys, there's great accountants, CPAs out there, but if they don't understand pharmacy, looking at financials can be difficult to really see how it's operating. So we get a lot of new clients that move to us where their monthly financials are cash basis. So they don't have receivables booked, which means that sales aren't correct. It means that gross profit is probably wrong. And so looking just at that is not going to give you good, accurate information. So there's adjustments that have to be made. 2 of the biggest areas are going to be that we see issues is receivables and inventory. We'll look at a set of financials for, a 4-year period and see that inventory is exactly $275,000 to the penny every single year at the end of each year. It's amazing. So obviously, when you look at something like that, you can tell that person is either they don't have a perpetual inventory system in place, they haven't had a count, or they're not adjusting to that figure. If your inventory is not correct, your gross profit's wrong. Same thing with receivables. If you're not booking those, then we don't have, and reconciling your claims, we don't really truly know what we're looking at if the receivables aren't on the books, what we're looking at if the sales figures are correct, which again affects gross profit. So those are the two big areas we try to down into to make sure we can make some adjustments and figure out what that true number is. We're looking at script audit logs. It's so important to look and validate how, if we're looking at an audit log for the year, for a couple years, are the sales going down? Are they going up? What's the breakdown between generics and brands? Does gross profit on those audit logs look reasonable with what we're seeing in the financial statements? All of those things. I mean, we see financials that show $6 million pharmacy, and then you'll look at the audit log for the year and it shows $4 million. So which is right, so those are the kind of things that we're looking at. And then we're just going in and pulling out and adding some of it is positive adjustments. Sometimes when you've got an owner that has all their debt paid, they could be paying themselves anything for a salary. It could be, $1 million salary per year. So we would obviously make adjustments for that to bring that back down to a payroll to a reasonable level, because that's what the buyer would be doing. And so that would make profit look better. So, and then obviously we're validating tax filings. We're looking, especially with a common stock purchase, we are looking to make sure tax returns have been done correctly, filed on time, and those sorts of things.
Monty, talk real quickly about, I think they're kind of old school, but there's still corporations out there that are C corporations, and talk about double taxation with when a C corporation sells its assets.
So yeah, if you've not made an S election and been in S corporation for a certain period of time, then you've got a C corp situation, and that goes for that's not going to affect in an asset purchase. That is not going to affect the buyer, but yeah, with a C corp, if you're selling that, you're going to be taxed twice, both at the sale and then later personally.
But if it's a stock if a person owns a C corp and he or she sells the stock, then the seller is going to get hit with capital gains.
Right.
Okay. So just be aware of that. Now,
I have a question, because a lot of the discussion is about how to do due diligence, and you're protecting yourself against the unforeseen. What do I know everything about the company I'm buying? And so assuming you're not always 100% successful in discovering everything out there, what are ways that a buyer can protect themselves in that eventuality?
Again, another positive thing about using someone who understands pharmacy, like Jeff.
Okay. Yeah, there's a bigger chance you're going to find all the warts if you have someone who understands the bit.
Yeah, but you're never going to discover everything. There's always going to be some unknowns. And so, Jeff, let's talk about having things set up there for that.
Okay. Yeah, and that's a good point, Miguel and Bonnie, and that is, if we are thorough with our due diligence, we're going to discover most things. We're going to have a pretty good feel for what we're getting. No different than when you buy a house. You got a pretty good feel that, the roof is kind of old, but it's going to last another 10 years. The plumbing looks like it's in pretty good shape. There's no termites. You pretty much know what you're getting when you're buying the house, but then you get some surprises after you move in. Likewise, buying a pharmacy with the due diligence, we're going to be gathering all this information about the pharmacy, and we're going to, we may know pretty much maybe 90% of what's there, but there will be a few, there'll be a few surprises. Well, here's how you protect yourself. The number one, if I'm representing the buyer, then I want to not pay all of the purchase price at closing. I want to hold back a portion of the purchase price, and I want to put that in escrow, or just some type of separate escrow account. And so let's say that my client buys Miguel's pharmacy for $3 million. I would like to hold back, I don't know, if I could wave my magic wand, maybe $250,000 to $500,000, and just put that in an escrow account and pay that holdback 6 months after closing. That way, there's a pot of money for me as a buyer to go against in the event that I find out that Miguel was being less than honest during the due diligence process. I'm asking Miguel for all kinds of information, and he's supposed to be forthcoming and give me everything. But let's say for whatever reason, he doesn't give me everything, and I get surprised after closing. Well, now
or I could be totally honest, which I would be, Jeff. But there could be still something else that happened, like an audit that I would never have known about, like that
Sure.
pops up and that I that you wouldn't have known about, or I wouldn't either.
That's a good point, Miguel. And so you just want, attorneys like to use the phrase possession is 9/10 of the law. And that is, if I'm the buyer and I'm possessing $250,000 of Miguel's money, then I've got some leverage here. I've got some security in the event that I get surprised after closing. That gives me protection. I like that. Now, in addition to that, the document that we're going to sign at closing, it'll either be an asset purchase agreement or a stock purchase agreement. They're very similar. But there will be two important provisions or sections in that agreement. One will be what's called representations and warranties, otherwise known as reps and warranties. And that's when Miguel makes certain promises, make certain statements about how great the pharmacy is, and he's not aware of any legal issues, and so on and so forth. So these are representations and warranties. In addition to that, there'll be an indemnification provision whereby Miguel, as the seller, indemnifies me as the buyer if any of these representations and warranties end up not being true. And so you've got these two provisions. Well and good, but that just gives me as the buyer certain rights on paper. Well, this protection that the contract gives me is only so good as Miguel's ability to honor it. For example, I could give to Miguel a $10 million promissory note. Legally, I am required to pay $10 million to Miguel Rodriguez. So what? I don't have it. Too bad. We don't have debtor's prison. You can do nothing about it. All of my assets are exempt. And so on paper, he's got this wonderful promissory note. In reality, he's got nothing. Well, likewise, with an asset purchase agreement or stock purchase agreement, yes, we're going to have these representations and warranties. Yes, we're going to have this indemnification, but that's only so good as the seller's ability to honor that. And so for that reason, I like having this holdback amount, this pot of money to go against in the event that there are any surprises.
And Jeff, do we normally see those with the stock purchases, right? The holdbacks. Not
more
so much
so
with,
so, but even then, yeah, I mean, a holdback is more important with a stock purchase than with an asset purchase. But as a healthcare attorney, I am paranoid by nature. Okay.
Oh yeah, why not throw it in there? Yeah.
Yeah. So I really want to hold back even with an asset purchase. I just in case.
But just so everyone understands, with the asset purchase, you don't have to worry about like an IRS audit, a payroll audit, something like that. Because that's going to be the sellers.
A PBM audit, you don't have to worry about
PBM audit, right?
Yeah. So, but the holdback amount, I mean, for example, if you're a seller, you don't want to hold back, you want all your money today. And so I think the amount of the holdback and how long the holdback is for become important points of negotiation. You want the holdback is supposed to protect only for these low probability unforeseen events. And it should be, over time, the risk of these liabilities popping up goes down. And so you want to, the point of negotiation between buyer and seller becomes, what is that reasonable amount of number to hold back, if any, and how long? Should it be 3 months or 3 years? It could be a lot of different things depending on the circumstances.
Yeah.
No, that go ahead.
No, I was just going to say, I know we're getting a little low in time. I did want to cover two things with you that I think I see a
Please.
lot that are very important. Let's talk about non-competes with the former owner, and I also want to talk about leases. Just give me your quick opinions
But
on both
yeah,
of those.
yeah. So if let's say Miguel's down in Austin, and so we got Miguel's Pharmacy Inc. Great reputation. Everybody in that area knows Miguel Rodriguez. They love his pharmacy. He's the man. And so now I am buying, whether it doesn't really matter whether it's the stock or assets of Miguel's pharmacy. After I cut him a big check at closing, I don't want him competing against me. I don't want Miguel to go across the street and open up a brand new pharmacy. I don't want Miguel to go to work for Bonnie's pharmacy across the street. I want Miguel out of the picture. And so I'm going to absolutely positively build into the agreement a non-compete that says, okay, Miguel, I'm about to pay you a whole bunch of money. You're out of here. And so he can't compete for a period of time and within a certain geographical area. That's really critical.
Yes.
In addition to that, but I might very well would need Miguel to stay on for at least 6 months as my employee, just to help with the transition. And so there at closing, in addition to signing, whether it's an asset purchase agreement or stock purchase agreement, we're going to sign a employment agreement where Miguel is going to be my employee to help with the transition. But then after that, he just can't compete with me.
Right.
From a lease standpoint, just be aware. I've seen, okay, I know we're running out of time here, but
Let me tell my horror story really quick because I
please.
work with a lot of startups and transitions, but purchases where people the first conversation they have with us after they've engaged us is, I already signed a lease. Like, no.
Don't tell me.
And no, and so just be really, the timing of transitions, no matter what you do, is so hard, but it's so important. But it's because there's a lot of things you have to have a lease signed to be able to start this process and this part of the process. But you just want to make sure, Jeff, that you don't lock yourself into some sort of lease that may not even end up working out. We've seen people sign leases and then they can't get their store open for a year, a year and a half.
For a year, yeah, and it breaks them.
And they're selling ice cream out front because that's all they can do right now for a year while they try to get contracts in place, and it's just a nightmare. So it's a hard thing to time.
It is, but if we could wave our magic wand, we don't. The lease doesn't go into effect until we know it's a done deal. We've got we're going to get our pharmacy license. Our PBM contracts are in place, or they're coming, or we know they're coming in. So that, as you said, the last thing I want is for my client to have to pay $7,500 a month rent with no income coming in.
Yes.
Now, if I could wave my magic wand, what I would do is have my client sign I don't care, 7-year lease, but with a jump out at the end of, jump out after 2 years, a jump out after 4 years. If I could wave my magic wand, I'd like my client to only sign the lease in its corporate capacity. In other words, John's Pharmacy Inc., John Smith signs the lease as the president of the corporation. That's it. Well, the seller's going to have nothing to do with that. Seller's going to say, nice try, John Smith. You individually have to guarantee the lease. I get that. But even then, if I could wave my magic wand, I'd like for that guarantee to drop off after a period of time. So just be aware that I guess the rule, I guess if you take nothing else from this, before you sign a lease, talk to a healthcare attorney and say, should I sign this lease?
And in a stock purchase, you want to make sure that lease is assignable, right?
Absolutely.
I mean, that would be terrible.
So
well, I think we're nearing the end, and I just wanted to interrupt for a second just to invite the attendees to hit the Q&A button at the top of your screen to submit a question, and I'll be able to read that off for Bonnie and Jeff, and you guys can continue. We can also continue this great discussion in the meantime, but just hit that button and post it, and then I'll be able to see that and can answer that question. This seminar is called Everything You Wanted to Know About Buying and Selling a Pharmacy, but We're Afraid to Ask. But please don't be afraid. You don't have to be afraid. These guys, this is the time to ask some great questions. That the amount of knowledge here is tremendous. So
this folks, this is as cheap as you're going to get Bonnie and me. So just go ahead and just ask away. One thing that I'd like to bring up. Stock purchase agreement, asset purchase agreement, reps and warranties. If I'm representing the seller, let's say I'm representing Miguel and he's selling Miguel's Pharmacy Inc. I want the reps and warranties to read like this. To the best of my knowledge, I represent that such and such. Well, that gives my client Miguel a way out. But if I'm representing the buyer, then I'm going to want that representation and warranty section to say, I, Miguel Rodriguez, I absolutely represent such and such. I want to tie him in or lock him in. If I'm on the other hand, if I'm representing Miguel, I want to give me a way out. That's all a negotiation ploy between the two parties. The other thing too is that as the buyer, let's make decisions on what employees you're going to keep and what employees you're going to let go before closing, and let's require the seller to actually make that decision and to pull that lever before closing. The seller wants your money as the buyer, so the seller is willing to do within reason whatever it needs to do for you to hand him or it a check at closing. And so if there are certain employees that you just don't want after you buy the pharmacy, that's fine. But let's have the seller get rid of them before closing, so you as the buyer don't have to mess with it. So in other words, employee issues, let's get those taken care of before closing.
And to be really clear on an asset purchase, Jeff, you are the new sheriff in town from day one. So you can use that time and ability to, if I was purchasing a store in an asset purchase, I would interview people just like I would be if I was, hiring for a new position, and figuring out who needs to be there. Because you're going to be in new payroll, ID numbers, and things like that. You're starting fresh with the payroll. So not bringing that person on isn't going to hurt, your unemployment insurance or anything like that.
We have a question for you guys about valuation. If EBITDA is useful in asset sales and stock sales, or just one or the other as a valuation tool?
Yeah.
Oh.
Is there any differences among them between why you would want to favor one more than the other?
I'm sorry. Are you asking?
Well, why would you use it more as a tool in stock sales than in asset sales, or is it about equivalent for both?
I think it's about equivalent.
Yeah.
Because that's really about the earnings and adding back, making adjustments for things. It's really about finding the value of the numbers and what that pharmacy is worth, which goes to your offer that you're going to make.
But besides looking at EBITDA, I know is there a per script, a value based on scripts, or any other useful tools for creating valuation models on pharmacies? Or is it strictly just EBITDA, and that's pretty much the goal?
We have personally at Sykes and Company about a 15 bullet point list of due diligence items that we work with people on, that we go through one by one, every single one, and that deals with EBITDA down to tax returns, down to just audit logs, script counts, controls, all sorts of things that we use to, obviously the due diligence we do informal valuations, but that all goes together to help us come to our value, of what we think the pharmacy's worth. So there's not really just, there are people that have little formulas and calculations that they use, but we value things based on the whole picture, and not just a per script situation.
Other than asset sales and stock sales, which are sort of these two high level distinctions between how you structure the transaction, are there any more exotic ways of structuring a transaction, and what might be an example?
I was going to
of that?
mention that, Miguel. I'm glad you. We could do another 2-hour webinar on what's called a 336E tax election that you can make. That's really a hybrid of the two. We love them. They're very complex, but it's a great benefit for the buyer in that transaction, because you technically do, you get the benefits of the common stock purchase as far as taking over ownership, getting closed earlier, and just walking in and transferring the stock. But you also get the step up and basis for things like fixed assets, like we talked about. You are actually able to allocate part of the purchase price to the fixed assets and things like that you can depreciate quicker. So it's a very complex tax election. Again, not a lot of attorneys have worked with those. Jeff's firm does. And it's just it adds a little kink to the process. Jeff, what would you say? Makes it a little more complex.
A little more complex, but it's definitely, from a tax standpoint, it's definitely worth it. And I know we have a pretty good sized corporate M&A group that works with Sykes and Company, and we've done a bunch of these.
But please don't try to do that type of setup without someone that has done many of them in the past. And we don't have a lot of CPAs. We've had CPAs contact us wanting us to help them with the tax side of those elections, because again, the tax return is very complex as well, the first one. But that's a whole nother topic.
Yeah.
But that is out there for those who are interested. And it's something that you've got to kind of get the seller on board with as well, but it can be a huge benefit.
From the seller standpoint, is there a disadvantage to doing that way? Or is it just, you just need to understand what's happening?
I think it's probably more beneficial for the buyer. But if you work out everything, it can make it a good situation for both. Again, that's why you just need someone, representing you as the buyer, someone representing the seller. We can all work together.
Having gone through these transactions, is there anything that you see as a common pitfall? I guess certainly I bet you people come to you having done transactions without expert advice, and then they see a problem. Are there typical problems that people see when they've closed a transaction and they come to you a few months later saying, "No, this is the problem I just came up with"? Anything that comes to mind as typical of those kind of problems?
I wouldn't say it's typical, but as much as typical, but I do remember, I was thinking about this while we were talking earlier. I remember working with someone who purchased a pharmacy, and this was a situation where there was one entity, but there were two locations in that entity structure. So that makes the due diligence even harder, because you've got to make sure you're looking at those financials, figuring out by location income and the expenses of what's allocated to each to see, what makes sense. We did not help this person with the due diligence process when he came to us. He had already purchased that one location. And what happened over time is we started to notice that the revenue wasn't there, that had been, construed to him that that's what it would be. And then when you started digging down into some old audit logs and things like that, we saw that, the revenue, what was shown on the financials wasn't what really, that's why the audit logs to me are very important to, that backs up that information. Are the scripts really there? So that's just a small example of, if someone had just looked at that, they could tell that what was being portrayed as revenue for that location didn't make sense. But we see that a lot. We have people come to us and it's just the information that due diligence wasn't done. And so what they thought they had wasn't exactly the case. But at that point, all you could do is move forward, get everything cleaned up, get your books on accrual basis so that you could really see how your pharmacy is operating. so important to do that on a monthly basis as well. And some people wait every 6 months, or the end of the year, they have someone jump in to make adjustments. But if you're not doing it monthly, you can't really understand how the pharmacy is operating. And you've got to adjust inventory, you've got to adjust your receivables to get those numbers.
One other thing to keep in mind too, Miguel and Bonnie, and that is if a pharmacy that you're buying also sells and rents durable medical equipment, or DME, that's a whole different animal. And so just, while usually by utilizing a power of attorney in an asset purchase, the purchaser can continue to operate under the seller's pharmacy license for a while until the purchaser gets his own pharmacy license. That's not the case with a DME billing number, otherwise known as a PTAN, PTAN, or Medicare Part B supplier number. The Medicare number that allows a pharmacy to bill for DME cannot be assigned or transferred, and the asset purchaser cannot operate under it until it gets its own. Certainly with a stock purchase, not a problem, but just be aware that the law, when it comes to DME, same thing as HME, home medical equipment, same thing. The law out there is kind of strange, and so just be aware that if the pharmacy we're buying does engage in selling or renting DME, that your attorney needs to understand what the law is, because it can come back to bite you if you're not careful.
Yep.
How about red flags? Is there anything that you would say you're either the buyer or the seller, and the other party, there's a characteristic and you say that's a red flag, you got to really watch out here, you better do some extra due diligence if you want to go forward, or is due diligence always important, I guess?
Mine is easy from the accounting perspective. When we have people who push back hard on sharing information, their tax returns, they don't want to share the QuickBooks file or accounting file. They don't want to show you the audit logs. We tell people to walk away. If they can't share that information, then
don't do. I agree with that.
And we see that a lot. And we have to tell people that really want the store, like, well, I really want it, I think it's a good deal. I'm like, can't do that. You can't do the due diligence we've talked about without all the pieces.
You have to accept the risk. If you're not going to take those pieces of information, you're accepting a lot more risk.
Absolutely.
Yeah, Miguel, it's like we said earlier, I've never known anybody to go broke by walking away from a deal.
Yeah.
And for every, and this sounds awfully cliche-ish, but bear with me, for every pharmacy out there that you gotta have, but you walk away from it, there are 10 others that are just as good that'll come your way. So just don't get emotionally caught up in the chase.
That's probably the emotion is probably there as a seller as well, and it's probably good advice to let people understand that if you want to sell a pharmacy, you're going to need to be transparent. You're going to have some levels of transparency.
And you have to have up-to-date records. We preach to people all the time as far as sellers, you need to be thinking ahead. So, it's not too early. If you know you want to sell in the next couple of years, you need to make sure you have everything up to date, your tax returns, your financial statements, just everything perfect. So adjusted and perfect so that when that time comes, you can easily, pass that information along in this process that we're talking about.
And we say the same thing from a legal standpoint, and that is if you think you're going to sell, let's just make sure your house is in order from a legal compliance standpoint. If we're compounding, fine. Let's make sure we are complying with our state regulations. Are we engaged in any type of mail order? Well, is that by engaging in mail order, are we violating our PBM contract? Are we doing anything right now that if it comes to the surface is going to hurt us? Because I promise you that if the buyer's attorney is even halfway sophisticated, he or she is going to uncover problems. And so, for example, if Fred's Pharmacy Inc. in Peoria, Illinois, um, is just generating a great net profit, but is doing so by delivering or mailing um, drugs throughout Southern Illinois, but its PBM contracts say you can't do that, then what are you buying?
Right.
And so, or what are you selling? And so, again, if you're looking at wanting to transfer or sell your pharmacy, make sure that not only from an accounting standpoint your house is in order, but make sure from a legal standpoint your house is in order, because if it's not, the buyer's due diligence attorney is going to find out.
Yep.
As a seller, I know we focus a lot on due diligence that the buyer has to do about the seller, but is there due diligence that the seller should do on the buyer? What's important to know about your buyer?
Well, from my standpoint, it's not nearly as important,
No.
because if I'm representing the seller, I want money. Okay. I went at closing. I want to make sure, if I'm selling my pharmacy for $3 million, if I could wave my magic wand, I'm going to get a $3 million check at closing. If I'm going to get instead a $2,750,000 check at closing, and then there's going to be a holdback of $250,000, okay, but I want to make sure that the escrow agreement, the document that governs this $250,000, allows me to fairly easily get that after 6 months. I don't want to have to go sue the buyer for it. And so,
I guess if the buyer is going to pay for the store through a promissory note, I suppose, or you'd want some sort of a.
Okay, you got another 2 hours.
Yeah, no, that's a great point. Yeah.
No, that's
You
true.
want to make sure they're going to pay, right?
Yeah, I mean, again, it's possession is 9/10 of the law. And so let's say that now Miguel sells his pharmacy to Jeff for $3 million. I pay $500,000 at closing, and then I give you a $2.5 million promissory note. Well, you're the seller. If I'm representing you, the seller, then I'm going to want to feel pretty darn comfortable that you're going to pay me that $2.5 million. For example, I'm going to want to know, I want it secured. I want some collateral. I mean, is the collateral going to be the stock of the corporation that you just bought? Is the collateral going to be all of the assets of the pharmacy? Well, that's very well and good, but is the pharmacy going to want to go out and get a working capital loan from First National Bank of Abilene? And how's that going to relate to my security interest? And so, as a seller, if you're going to get all or almost all of your money at closing, then I, as the attorney representing the seller, I'm pretty relaxed, because really all I want is money. But if instead I'm financing this thing through a promissory note, then it's a whole different ballgame. I've got to make sure that I'm comfortable that the buyer's who it or he or she says he is, and that has the ability to make payments, and that my promissory note is properly secured.
Yep.
Make sense?
That makes total sense. Yeah, that you are basically still in the pharmacy business with a promissory note, because if the pharmacy is not successful, then you're not going to get your money back.
You're not going to get your money. If John Smith, who buys my pharmacy, goes out and does dumb things, engages in mail order or that he shouldn't, or waives co-payments that he shouldn't, or gets caught up in the the weight loss drugs like he shouldn't. And then all of a sudden, this pharmacy that I just sold, that I've got this promissory note back, if now the pharmacy gets all of its PBM contracts are terminated, then all of a sudden I'm not going to get paid because there's no income coming in. As a general rule, unless you're selling to a family member, a son or a daughter or something like that. There are banks out there that specialize in lending money for pharmacy acquisitions. If I'm representing the seller, I'm going to be pretty insistent that the buyer go out and get a loan.
I think that's a great point to make when we talk about using someone that understands pharmacy with your healthcare regulatory issues, with your accounting. That goes with banks as well. We could do another webinar on that, financing and how important it is to use a bank, a pharmacy niche bank that understands pharmacy transactions to make sure that you're fully capitalized, that you've got enough working capital as you grow, and that you're covered. And like Jeff said, a lot of these will, for a very small portion of the purchase price, will, if it's a good deal and you've done your due diligence and you show them that information, they will cover a good portion of the loan.
Yeah, there banks, but you've got like whether it's a Live Oak or a First Financial or you got some others out there, they make SBA loans. And you know, if you can show that you know what you're doing and you got good financials and a good business plan, you're going to get you're going to get financing.
Yep.
Great. Well, we're over time. I really appreciate your knowledge and time. There's a last minute question. Get it in now because we're going to need to wind it up. But Jeff and Bonnie, Bonnie, I mean, on short notice with no preparation,
No problem.
you gave a
Jeff and I have done
masterclass
this
here.
Many times.
And that just shows what experience is all about, because you know, having this kind of knowledge at the tip of your tongue, just ready to go, is a valuable tool. So expertise is very important. There's a lot of little intricacies that most people don't consider when they go into these transactions. They think of either purchase price or sale price, and that's pretty much about it. So you got to make sure you're protected one way or the other. So thanks so much for your time. I appreciate it.
You bet, Miguel. And thanks, folks, for attending. And you're in American Pharmacies. It's a great organization. You're very smart to be part of it. So
fantastic.
All right,
well, thanks so much, everybody.
Thanks, Bonnie. Bye bye.
Thank you, guys.
See you now.
Have a good day.
Bye bye. See ya.
Bye.
You too.